Hello everyone, this is Derek Teeter, a partner in Husch Blackwell's Higher Education Group. We're excited to give today's presentation on recent updates to Title IX compliance. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later by email. We appreciate audience participation and encourage you to submit your questions. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. Indiana credit is pending. To report your hours to these states, click on the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of compliance. Joining me today is Elizabeth Samples. Elizabeth is an attorney in our higher education group as well, and her practice focuses on serving the unique needs of both public and private schools in many areas, including Title VI, Title IX, the Clery Act, Section 504 of the Rehabilitation Act, and many others. So with that, let's dive into our webinar, a Title IX compliance update. So it's my practice to always start a Title IX webinar or live presentation with the actual text of the law that we're talking about. So on your screen now is the language of Title IX from its implementing regulation. We're talking about a law that prohibits sex discrimination in the education programs and activities of institutions that receive federal financial assistance, which of course almost all of you do through, at a minimum, student financial aid. So this notion of discrimination in programs and activities is a theme that will come up in a few of the points we're talking about today. In particular, some areas where we hope to get additional clarification from the Department of Education, and also some new cases that have come out in the last few months on that subject. So one large change in our compliance posture over this time last year is that the Department of Education issued a new Dear Colleague letter on Title IX compliance in September of 2017. So our September 2017 DCL, as we call it, did a number of things, but the most significant thing that it did was to rescind two key pieces of the prior administration's informal Title IX guidance, namely the 2011 Dear Colleague letter that sparked much of the compliance change we've experienced in the last 7 years, as well as the follow-up 2014 sexual violence FAQs. So those documents from the prior administration are no longer binding. And if you look at them on the department's website, they have a big red archive stamp over the top of them to indicate that they're not currently operative guidance. Now, there are some specific points in those rescinded pieces of guidance that nonetheless are legal obligations, either because they come from the statute itself or because they originated in other guidance that predated the rescinded guidance. And the most significant piece of that is the 2001 revised sexual harassment guidance, which is still good guidance, binding, and pointed to by the Department of Education as a piece of guidance that we all should conform ourselves to. That's a 50 to 60 page document that was issued in the Bush administration, and which, unlike the more recent guidance, went through formal notice and comment rulemaking. And so it's more formal in that sense. The Department's September 2017 Dear Colleague letter was also accompanied by a new set of questions and answers. So together, that 2001 revised sexual harassment guidance and the new Q&As sort of form the primary corpus of guidance from which we assess Title IX compliance at the moment. Now, there are some other Dear Colleague letters focused on very discrete topics like the First Amendment or bullying that sort of bear on this space as well. But 2001 guidance, the Q&As from 2017, are really where we go to for the bulk of our compliance assessment at the moment. So in thinking about the 2011 and 2014 guidance being rescinded, I think it's helpful to identify sort of the new and significant pieces of our work over the last 7 years that came out of that rescinded guidance. Because, of course, the effect of rescinding that guidance is to rescind, arguably, the force of these sort of dictates that were in it. We had the expected 60-day time frame for the completion of investigations, the mandate to use only preponderance of the evidence standard, the requirement to allow appeals for both parties, a fairly direct discouragement of cross-examination for those of you that have a hearing model of resolution, a ban on the use of sexual history and evidence except as between the parties to a case. That rescinded guidance also was the root of the notion that a school can't satisfy its Title IX obligations by relying on local law enforcement investigation, even of off-campus conduct. And many people construed at least the 2014 FAQs as suggesting schools had to investigate all reports of sexual misconduct regardless of location, whether on or off campus, and regardless of the context, whether occurring in a university-sponsored activity or not. The guidance also had some language about interim measures. And by interim measures, of course, we're referring to steps a school would take during the pendency of an investigation to perhaps separate the parties or to avoid the situation deteriorating further. The rescinded guidance suggested that if we had to pick between burdening one or the other parties, we should err on the side of burdening the respondent rather than the complainant. So that language is gone, and you'll see when Elizabeth takes over the webinar some alternative direction that's been given in the new 2017 Q&A. So, why did the department decide to rescind this guidance, or at least what's the explanation that's been given? There's several. First, at sort of a technical legal level, the department said this prior guidance effectively imposed new substantive mandates. And under federal law, and specifically the Administrative Procedures Act, before an agency imposes new substantive mandates, it's supposed to issue proposed regulations and allow the public to provide comment, and then to finalize those regulations only after it has considered the comments that it received. So the department is effectively saying there's a procedural flaw in how the old guidance was issued, and that notice and comment wasn't followed. There's a substantive critique built into the rescission as well. The current department and administration are very much attuned to questions of due process and fairness. And so, in their view at least, certain elements of the prior guidance tip the scale too far in favor of complainants, depriving respondents of fundamental fairness in some cases, leading to a deprivation of rights in some cases, perhaps particularly as it pertained to interim measures. And the final two critiques, one being that the prior guidance was sort of billed as providing greater clarity, but in the eyes of the current department didn't succeed at that and may have actually created greater confusion. And then finally, the question of sort of the regulatory burden that the prior guidance imposed being significant. All of this is sort of interesting just to know the department's mindset, but these explanations are also important for thinking about where is the department going and how is it going to advise us as to Title IX compliance issues in the future. So in that September of 2017 Dear Colleague letter, as many of you may know, the department announced its intention to go through a formal notice and comment rulemaking process. And those of us in the space have been waiting attentively for the last 6 months, really, for the department to issue its new proposed guidance and to open a notice and comment period. And I'll confess, when we scheduled this webinar and picked this title, we anticipated that we might actually have those proposed regulations to talk about by this point. But we don't. And we can speculate as to the reason for the delays. There's certainly been a lag in confirming sort of mid-level and second-tier administrators for the department, which may be part of the delay. But suffice it to say, they continue to indicate that soon we'll get these new proposed regulations from the department, which will, I'm sure, in substantial part track much of what was contained in the September Q&A, but probably elaborate upon that and also hopefully address a few different issues that currently are sort of sitting out there, at least in our view, with a lack of clarity for institutions. So with that, I'm going to turn it over to Elizabeth to walk us through some of the substantive changes that come in those September Q&As, and we'll get now into the part of the presentation where we talk about what this means in practice for you all. So Elizabeth? Okay,
thank you, Derek. So we'll jump in now and talk about some of the major components of the September Q&A, as Derek mentioned, as we're waiting for the new regulations. So starting with this issue of promptness, certainly the 60-day time frame is a timeliness standard that has become well known to schools that was included under the prior guidance. The new guidance, however, states that there is no fixed time frame under which a school must complete a Title IX investigation. So rather than looking at a strict 60-day expectation, OCR is going to look at a school's good faith effort to conduct a fair and impartial investigation in a timely manner. So when thinking about this over the course of an investigation, even without a 60-day expectation, schools are still going to be considering the same main timeliness issues as we did when that expectation was in place. So still, of course, maintaining efforts to move the investigation along, accounting for reasonable delays, keeping the parties informed, of course, as we proceed through an investigation. But there's going to be a more relaxed expectation with respect to exactly how long that takes. And the guidance that still remains, and it's also addressed in the Q&A, still includes a provision that schools designate and follow reasonably prompt time frames. So even if it's not a 60-day expectation that's explicitly included in our policy, we should still have these sort of benchmarks for how our investigation process is going to unfold as we're trying to seek resolution in these matters. Of course, another significant change was a relaxed expectation with respect to the standard of proof that is used. So as we know under the prior guidance, it was an expectation that preponderance of the evidence standard always be used. Now schools have the discretion to select preponderance of the evidence or a clear and convincing standard. However, the standard which is utilized in sexual misconduct cases has to be consistent with the standard that is used in other forms of student misconduct issues, and that's explicitly addressed in the Q&A. This is, of course, significant because while schools may have been thinking that clear and convincing standard would be more appropriate for matters related to sexual misconduct, they may, by the same token, still really like to maintain the preponderance standard for other sort of various student misconduct issues. And the guidance makes it clear that those need to be aligned. So this brings us to our first poll question, which is asking you whether your institution is considering changing the standard of proof used in cases of sexual misconduct. And your choices there are yes, no, I don't know. So I'll give it a minute here for some responses to come in. So far we're not seeing anyone who's responding that they are considering changing the standard of proof. And this is likely explained by what I just described, which is the idea that in practice, institutions are not interested in changing their standard for other types of cases.
Yeah, it looks like we have a small minority, but just to put a very explicit example on this that came up in a presentation I was doing the other day was, well, what about all the drug and alcohol violations, and we smell marijuana in a dorm room, or we see some empty beer cans. Do we really want to have to prove that someone underage drank by clear and convincing evidence? Do we really want to have that standard for all those sorts of cases that really drive the bulk of our student conduct work? And that particular client said, no, we don't. So I think you're seeing some of that kind of reasoning reflected in these responses.
Right, that's right. Okay, so the next category here is the issue of appeals. So the withdrawn guidance, as Derek mentioned earlier, did require a mutuality of appeal. And the new guidance has made it explicit that if a school chooses to allow appeals, it may choose to allow appeals for only the responding party. Alternatively, it may choose to allow appeals for both. And of course, if it does allow appeals for both, it must do so on an equal basis. So on this issue, in the Q&A from September, the department did reference OCR decision letters prior to the Obama administration that discussed this issue of appeals. And in those letters, it talked about how an appeal right was not required for a complainant, and that it was permissible to allow an appeal only for a responding party. Of note here, it's important to consider your state law and what may still be required under your state law. So although obviously the department has issued its guidance with respect to this issue, state law may still require mutuality of appeal. So an example there is Illinois' law preventing sexual misconduct in higher education. It still does require mutuality of appeal. So next, on the issue of interim measures, of course we know that interim measures serve an important function during the course of investigations and our resolution process of these matters. Even before the guidance was in flux a bit, this is an area I think where we provide a lot of client counseling as schools try to navigate what needs to be put in place while an investigation is being carried out. So, of course, we know that these interim measures can serve an important function, preventing further harm from occurring, potentially preventing ongoing discrimination. So under the withdrawn guidance, when taking interim measures, schools were directed pretty explicitly to minimize the burden on a complainant. Alternatively, the new guidance from the department highlights the importance of making interim measure determinations on a case-by-case basis and applying these decisions fairly to both parties. So if, for example, schools had language in their policies such as any interim steps will be taken in a manner that minimizes the burden on a complainant, that type of language should be removed from the policy given this recent guidance. So schools should make sure that interim measures are available again to both parties and that they're not relying on assumptions that favor one party or another. So in practice, these are issues that really require sometimes some creativity in coming up with solutions and really sort of engaging the parties in their, with respect to their course schedules or their housing situations to try to figure out how we can, one, find interim measures that really produce minimal burden on either party, and when some kind of burden is necessary, that we're really making sure that we're engaging in sort of an interactive process to make those decisions fairly. And also, you know, when initially it may seem like interim measures we're running into sort of a roadblock about a solution, we do sort of encourage you to kind of push back and continue to explore different options to really try to, again, minimize the burden on both parties. So the next issue relates to written notice of the investigation, of the complaint. And in our experience, schools have historically handled this aspect of complaint resolution very differently. Some providing very, very minimal detail about the complaint allegation, just referring to the fact that there's been a complaint under the policy, and others across the spectrum have already been really providing detailed notices. What the Q&A has done is really provided direct notice about how detailed these written notices should be. It states that there should be sufficient factual details, identifying the parties, identifying the specific policy provisions that are at issue, identifying the precise conduct, and identifying date and location. And of course, the idea here is that it allows respondents the opportunity to adequately prepare for this initial interview about the complaint allegations made against him or her. So some schools have been kind of resistant to putting too much detail into these written notices, with the idea that it could get leaked and create more conflict, could create issues for both parties. And that's really a concern with any sort of, Title IX kind of documentation that we're creating. And really what it does is highlight the importance of putting the anti-retaliation admonition in these notices to sort of counteract that concern about it getting released or being used for some sort of negative purpose. And then also notifying the complainant when the notices will be released so that he or she can anticipate that. But on balance, this really does serve an important process point for both complainants and respondents as they're preparing to engage in the investigation process. So here's another poll question for us. Providing pre-interview notice is a good or a bad thing? Give everyone a moment to submit their responses. Okay, so as the responses are coming in here, we're seeing kind of an overwhelming response that it is a good thing. So that does sort of go to what I just described, which is really the opportunity that it allows for the parties to really prepare as they begin to engage in the investigation process. It also does serve, I think, an added benefit to the investigator as he or she is beginning the process to engage in making, sort of gathering facts and making a determination under the policy. The more clear everyone is at the outset of an investigation about what is actually the identified misconduct and what facts we're trying to gather towards that end, the better the outcome is going to be in terms of getting to the right outcome in the investigation. Also, related to the issue of adopting our policies with respect to the investigation process, we have new guidance that talks about the party's opportunity to respond to a report in advance of a decision of responsibility. So the way that schools have to adjust their practices on this point are really going to vary depending on the resolution process that is implemented by the school. So, for example, in situations where there's a hearing model, the report writing process may not need to change very significantly because a determination is not made within it, and the parties still have an opportunity to respond to the details in the report at another point before a decision is made. If, however, a school is utilizing a strict investigation model, schools may need to move towards a practice of creating a preliminary report so that the parties have an opportunity to respond to it before a decision is made. So just in summary here, the things that we've been discussing all do sort of amount to recommended policy changes that we would suggest that you make. So first, that parties are provided a pre-interview notice with sufficient details and with sufficient time. This is, of course, an issue that may be addressed in the policy itself, sort of outlining that commitment to what notice you will provide, but it is certainly something that in practice you should be implementing as you're sending out these notices. Secondly, removing the language about the burden of interim measures falling on respondent more heavily. Again, removing that language if you do have it currently about minimizing the burden on the complainant. Third, addressing any inconsistent standard of proof that may exist. If, for example, you had previously had preponderance of the evidence for sexual misconduct cases and a higher standard in your student conduct cases, you're going to want to make sure that those are aligned given the September guidance. And then finally, providing a predetermination review of the report and allowing the parties to provide written comment to it. We thought it may be useful on a couple of these points to provide you with some sample language to kind of highlight the ways in which you may consider changing your policy on some of these points. So here, this is one that sort of talks about this written notice. So once a decision is made to pursue an investigation, the university will provide written notice to both parties, and it will include a description of the parties involved, the specific sections of the policy allegedly violated, the specific alleged misconduct, and the dates and locations of the misconduct. Then it talks about that the written notice will be accompanied by rights and options, of course, and allows 3 days for the parties to sort of process that notice and prepare for any subsequent interview. So what this policy language does is it notifies community members not only of the content that our notices will include, but it also highlights the reasoning for this by giving that time frame for individuals to prepare for the initial meeting once they have received that notice.
So this might be a good spot to address two similar questions that we've gotten, Elizabeth, that sort of bear on this. One is, when would you consider the investigation to be opened for purposes of this notice requirement? And then relatedly, someone asked, do the changes to written notice include both an obligation to notify about what the question is calling a preliminary investigation versus a formal investigation? And I might, if I could, go straight to the language in the FAQs because I think there is an insight here that's important. The language says once a school decides to open an investigation, quote, that may lead to disciplinary action, close quote. So I think in thinking about this, if any of you have been to our trainings or even on some prior webinars, we say that sometimes you may receive a report of potential misconduct, but you need to conduct maybe what we call a little I investigation or preliminary investigation to determine whether it even implicates your Title IX policy. And sometimes that may only amount to an interview with the complainant who might say, no, I didn't suffer that experience, or maybe it becomes clear at that point that you have a Title VII race issue instead of Title IX. I don't think the guidance is suggesting that you need to provide written notice when you're in that sort of preliminary evaluation phase. But once you decide to pursue what many of your policies would call the formal process or a formal investigation, where you know that at the end of it, a finding in favor of the complainant could lead to discipline, that's the point at which the guidance is saying you need to provide this detailed written notice.
Okay, and just one more example here of potential changes to your policy language, this time related to report writing and providing parties the opportunity to review and respond to a report before a determination is made. This language states that an investigator will prepare a preliminary report summarizing the evidence collected, and then each party will have 5 business days to review the report and provide any comment or response. Thereafter, the investigator will finalize the report and include a determination as to whether or not the respondent was found to have violated the policy. So here again, we've highlighted both that the parties have an opportunity to review the report, and we've made it clear that this is a predetermination review, so that parties have that opportunity to review and comment beforehand. So previously we highlighted some of the recommended policy changes that you should be making on the basis of the new guidance. These are issues where schools may want to consider making policy changes depending on your institution. So first, think about removing the 60-day time frame. Depending on how this has been working for you and your institution, this may or may not be something that you want to remove from the language. Also, considering what standard of proof is going to be the one that will be utilized at the institution for both sexual misconduct cases and for student conduct cases. Also, making determinations about your appeal process, whether you want to continue to allow appeals for both the complainant or the respondent, or whether you want to consider allowing an appeal only for the responding party. Also, as we mentioned at the beginning, the Q&A does sort of relax potentially the strict prohibition on sexual history evidence. So there may be situations when discussing the past sexual history may be relevant when, for example, it's put in dispute by the complainant's own allegations. So you may want to think about how you want to address this in your policy moving forward. Also, again, a discretionary piece, whether you want to consider removing language that maybe previously prohibited parties from engaging in cross-examination in a hearing process. And then finally, potentially aligning or changing your language with respect to off-campus activity and really moving it towards the programs and activities analysis. So in the 2014 guidance, there was, as Derek mentioned, sort of more significant discussion about off-campus conduct, and people really interpreted that to require an investigation regardless of where that conduct occurred. The new Q&A has emphasized this focus on programs and activities of the institution, and so you may want to consider adjusting the policy language to reflect this analysis. And a final example here, when considering potentially changing your policy language from the 60-day time frame to conducting your investigation in a reasonably prompt manner. So here it highlights, again, the considerations that may be in place that may require the investigation to take slightly longer. And so some institutions are choosing to revise their policies to reflect a timeline that more closely aligns with how long it's typically taking you to resolve these investigations and these complaints in a full and fair way. The important thing to know here is that if there's an investigation from OCR, OCR is always going to hold schools accountable for what it says in its policy. So if a school wants to take advantage of this relaxed standard from the 60-day time frame and instead use this reasonably prompt time frame, it's going to need to adjust its policy language to reflect that, because again, OCR will be looking to the commitments that the institution is making in its policy. So here we've highlighted some issues that have been sort of potential areas of confusion, particularly now that the guidance has been withdrawn. Things that were really highlighted and emphasized in the withdrawn guidance that was not addressed in the September guidance that sort of leaves a void. And so we're hoping that maybe there will be some clarity provided in the new guidance. So first, the withdrawn guidance clearly discussed the expectation that a law enforcement investigation does not relieve an institution of its duty to resolve complaints. Again, now this is withdrawn and it's not addressed in the Q&A, so hopefully we'll get some new guidance on that point. Again, with respect to the hostile environment, the Q&A focuses on the program and activity analysis and highlights letters, again, that talk about universities not having a duty to address incidents of harassment that occur off campus and do not involve a program and activity of the recipient. The Q&A goes on, however, to include a footnote that says that schools are nevertheless responsible for redressing a hostile environment that occurs on campus, even if it relates to off-campus activity. So the new guidance will hopefully provide us with some clarity on this analysis. That is, what does it mean to redress a hostile environment on campus that is created by off-campus conduct? The withdrawn guidance also included detailed information about how OCR expected schools to balance individual requests for confidentiality with the school's obligation to respond appropriately to reports. Now that this guidance has been withdrawn, it leaves a bit of confusion on this point. So the Q&A from September does acknowledge that individuals may request that action not be taken, but it then does go on to highlight schools' obligation to respond to instances of sexual misconduct. So the current guidance still does focus on the fact that schools need to take steps to understand what occurred and to respond appropriately. So perhaps the new guidance will give us some further clarity on this issue of reluctant complainants. Similarly, the withdrawn guidance included details about responsible employees and their obligations. We do still have some guidance related to responsible employees that remains. The 2001 guidance does address responsible employees and outlines who those people are and what their obligations are. But again, this may be an issue that gets further clarified in the new guidance. And finally, the issue of protected speech versus actionable harassment. And there's a discussion in the 2014 guidance on this issue that has been rescinded. Nevertheless, there is some guidance that remains from 2003. And with this administration's focus on First Amendment issues, this is likely an issue that may be addressed in the new guidance. One final point here. We have been seeing a trend as schools are working through these often complicated issues related to students and other community members. The investigation process that we endeavor to make a determination about what occurred and whether there has been a policy violation only goes so far to actually addressing the issues that have occurred for individuals under this process. And so we are seeing an expansion of counseling, a use of third-party partnerships to help provide these supports and resources to students, and also a focus, a recognition, if you will, that sometimes the resources that we're providing on main campus and our students there may not be as robust as the resources that we're providing to our students on satellite campuses, and trying to address that void that may exist there. So one final poll question here for my section. My institution has hired new student support positions in the last year. Give it a moment for some responses to come in. So we're seeing a little less than, okay, so about a third of you are saying that you have had the resources to hire new student support positions in the last year, and I suspect that, again, some of that may be due to resources, right? We recognize that in an era of limited resources, it can be hard to really get the student support staff that you feel you need, but it seems like at least some of you have been able to sort of focus some resources in this area as well as sort of in the investigation and resolution process under your policy.
Well, thank you, Elizabeth. Let me pick up with another trend that we've seen in light of the rescission of the prior guidance, and it's actually a rise in litigation risk. I think this may be counterintuitive to some people who believe that with sort of the pullback of the regulatory pressure, if you will, we would see an overall decrease in the litigiousness of Title IX cases. But if anything, we've seen an increase. Part of that may be that advocacy groups are taking to the courts to pursue certain objectives where they don't have an audience with the current department, and just the natural sort of rise in the development of both complainant and respondent bars, if you will, lawyers who are competent and able to take these cases. But we've seen an increase both in Title IX lawsuits filed by dissatisfied complainants, also an increase in lawsuits filed by respondents, typically alleging some sort of due process or fairness violation. So, there's in some ways a void left by OCR's pullback on some of this that is being filled by a continued increase in lawsuits running the full gamut of the Title IX universe. So the overall risk profile, if you will, for an institution may, if anything, have gone up because there are more concrete and likely financial penalties coming out of litigation than there would be in some ways from regulatory enforcement. Another trend we've seen that also has potential significant financial risk for an institution is an increasing risk under the Clery Act. So as many of you know, the Clery Act applies to our obligation to track and report certain crimes that occur within our geography, and also to publish an annual security report with certain policy statements and to provide trainings. And unlike Title IX, which doesn't have a clearly delineated fine structure, simply the ultimate penalty is losing your eligibility for federal aid, under the Clery Act there is a $55,000 per violation fine. And so not logging or reporting a sexual assault on campus can have a very concrete financial penalty under the Clery Act in a way that it wouldn't under Title IX. So we're seeing a rise in persons who are willing to utilize the Clery Act as a way of making complaints, especially if they believe that they don't have the efficacy through a Title IX complaint. We're seeing an increase in the number of program reviews, so this would be an effort by the Department of Education's Clery Compliance Division to assess a school's Clery compliance, and oftentimes that's tied to a broader review of compliance with a number of other financial aid imperatives too. And the Clery Act, of course, is statutory, passed by Congress, amended by Congress through VAWA, the Violence Against Women Act Amendment. So the current administration has shown a willingness to enforce these statutes, certainly in a way that it has not been willing to enforce informal guidance. So we see an increased risk of Clery Act violations sort of overlaying the subject matter that we've been talking about. Another trend is the growth in cases where we have an intersection between mental health concerns or disability concerns under the Americans with Disabilities Act and Section 504 on the one hand and Title IX on the other. So this could be one or both parties coming to a Title IX case with a pre-existing disability and the need for accommodations, or it can be a case where someone claims a condition resulting from a sexual assault that qualifies them as disabled under these laws and entitled to certain accommodations and other measures. And so these are both occurring more frequently at the institutional level, where our schools are having to deal with parties that have these overlapping concerns. Often that means greater collaboration between the Title IX coordinator and a disability services coordinator. It often means much more rigorous attention spent on academic accommodations and housing and the like. But we're also seeing a number of lawsuits filed now as well, where parties are pressing claims under all three of these statutes at the same time, arising from a Title IX investigation. So the need for Title IX coordinators and Title IX team members to be up to speed on the ADA and Section 504 and what obligations a school has to respond to students with disabilities, I think, is becoming even more apparent. Okay, a couple more trends. One is the subject of gender identity and trying to get some greater clarity in the law as to what exactly Title IX does or doesn't require. So there's a fundamental legal dispute working its way through the courts, and we think back to Title IX's prohibition on sex discrimination. The legal dispute is, what does the term sex mean? Is it referring to the physiological sort of anatomical expression of that, or does it also capture one's internal sense of gender, which of course could vary from their anatomical structure? So we have a number of cases that have been decided in the last couple of years, divergence amongst the courts, but these cases are escalating up through the courts of appeals with decisions being issued from courts like the Seventh Circuit that controls kind of the upper Midwest, a new decision coming out of Virginia, which I'll talk about in a moment, all of which are probably pushing us towards the Supreme Court taking a case either next year or the year after, where we hopefully get some definitive guidance as to whether Title IX does include gender identity discrimination or gender stereotyping discrimination. The next trend, I think many of you have been, since 2011, implementing some sort of climate survey or sort of a broad statistical attempt to assess the incident of sexual misconduct on campus and the efficacy of training and other concerns. Those surveys are certainly valuable to an extent, but they are, of course, subject to selection bias and various other things. And so we're seeing a trend of institutions trying to augment those climate surveys with a more qualitative climate review, if you will, an attempt to go into a particular segment of campus, maybe a particular unit, and do focus groups and interviews and really spending a great deal of time talking to people to try to assess where there are problems or where more resources or training needs to be brought to bear. You might see this technique being used on something like an athletics department, or if there's a particular academic unit that has had a number of complaints coming out of it. This use of a climate review, something that schools are doing more and more. Another trend, a rise in historic reports. So one artifact of the Me Too movement and sort of the broader public airing, if you will, of historic sexual harassment is that we're seeing more of those types of complaints being reported on college and university campuses too. And by historic, I mean not a report of something that happened a month or two ago, but something that happened several years ago, or perhaps an existing employee did something 10 years ago, and now it's being brought forward by someone who's felt empowered by the Me Too movement and what's going on in society generally. So this is causing institutions both to sort of reckon with these historic cases, but it's also presenting some real challenges from an investigatory perspective and the practical ability of an institution to determine 10 or 20 years after the fact what happened at some point. But nonetheless, there is a Title IX obligation to try to figure out what happened and certainly to assess whether there's an existing risk. But I'm curious, this will be our last poll question for the day, whether your school has received a historic Me Too report under Title IX in the last 6 months, and whether or not you're sort of feeling the trend that I'm talking about. So we'll give you all just a moment to respond to that and see what the sense of the audience is. Yeah, so I mean, this is interesting. We have, roughly a third or so of you who are saying that your school has received one of these historic reports, and that's a pretty significant number that I think we would expect will continue to increase, certainly as the Me Too movement continues to sort of drive a public narrative. Okay, the final trend then, I wanted to offer a few additional insights on some substantive trends in litigation. So litigation as a whole has increased. I think will continue to. We have these ADA Section 504 Title IX blend cases that we're seeing coming up in federal court. Respondent due process claims continue to be filed in increasing numbers. And also now it's common that a respondent will pair that due process type claim with a claim saying the institution's policy and practices are discriminatory in nature, that they are predisposed to produce an outcome adverse to the male party, separate and apart from these concerns about the adequacy of notice and an opportunity to be heard, which are part of due process. We also see a rise in the number of Title IX retaliation claims being brought. And that's retaliation not just by persons who have made complaints, but sometimes persons who are involved in the Title IX process at your school, whether as a witness or as an investigator or otherwise. So we could spend 2 hours talking through a whole bunch of interesting cases over the last 3 months, but I pulled 3 to share with you today and to mention. One is a case from the Ninth Circuit Court of Appeals, which of course controls federal law on the West Coast. It's a case called Samuelson versus Oregon State University. For the lawyers on the call, there's a whole interesting discussion of when the statute of limitations for a Title IX claim accrues. But for purposes of today, I'd offer Samuelson as a case that is getting at this notion of a school's programs and activities and where Title IX obligations go or don't. So in Samuelson, the plaintiff was a young woman who was sexually assaulted off campus in a private apartment by a non-student who then sought certain assistance from the university and wasn't happy with the assistance she received and ultimately withdrew from the school. And so the Title IX claim was against the school for alleged deliberate indifference to the concerns the student brought forth. And the trial court granted a judgment in favor of the school saying, essentially, this assault didn't occur within the school's programs and activities. It was off campus in a private setting. It wasn't part of some school activity. And so there wasn't a Title IX obligation. And the Court of Appeals agreed with that in the Samuelson case. Another decision that I think is very interesting is Doe versus the University of Notre Dame, a case out of the federal court in Indiana. Ms. Doe was a reluctant complainant, if you will, someone who did not come forward and make a complaint, but the Title IX office learned of a potential sexual assault of her and proceeded with a formal investigation really over her objections. And so ultimately she pressed a Title IX claim against the university, alleging that it was deliberately indifferent by moving forward against her wishes and that it caused her harm by investigating a case that ultimately was not resolved with a finding of a policy violation. And the court rejected this argument on her part, effectively saying that, look, if an institution decides for its own risk purposes that it needs to move forward, that doesn't give a Title IX claim to a reluctant complainant, especially where there's a reasoned basis for the school to want to press the investigation. And then the final case I'll offer, and I'll offer it because this very well could be the case that the Supreme Court ultimately takes to resolve gender identity issues, Grimm versus Gloucester County School Board. This case was actually in front of the Supreme Court a year and a half ago and was remanded or sent back down to the trial court after the department's transgender guidance was struck down and then withdrawn by a court in Texas. So Grimm is a case where a transgender student challenged the school's bathroom rules and prevailed at the trial court level only a few weeks ago. The court concluded that claims of discrimination on the basis of transgender status are per se actionable under Title IX because they're in effect gender stereotyping. So in essence, holding that Title IX does capture discrimination based on one's internal sense of gender, or at least to the extent that one is excluded from doing things based upon presuppositions of how a person of a given gender ought to behave. This case also has a constitutional analysis under the Equal Protection Clause because Gloucester County School Board is a public entity. So this may be the case that makes its way back to the Supreme Court sometime soon. So with that, it looks like we've got a number of questions that we can try to work through here in the last 7 minutes. So I'll pose the first one to Elizabeth to answer. We had talked earlier about this need to show the parties a copy of the report before it's finalized. So the question is, are you talking about the summary report that's prepared after an investigation?
No, so this would be basically, again, before a determination is made, but one that does include a summary of all of the information that has been collected, sort of who's been, what witnesses have been identified, what they shared, what the parties have both shared, and it's sort of providing that then before the investigation is actually concluded, that is, before a determination has been made. Another question that we had that kind of relates to that is whether we need to let the parties actually see any written response to the report, the preliminary report. Certainly that is the practice of some of our clients. I think that two important points here. One, of course, we need to be consistent with both parties and make sure that they have the same access to that information. And the second is really just to highlight the purpose behind this, right? It's to make sure that the parties have an opportunity to respond to everything that's being considered when making that determination. So that may be able to be achieved short of providing them the actual copy of what the parties have said, as long as the investigator is truly analyzing that information and making sure that to the extent there is new information that has been provided in that response, that either party has an opportunity to, again, kind of respond to that before it is used to make a determination.
Another question focuses on our discussion about the need to provide written notice to the parties, once the investigation is moving forward. And the question is, well, what if someone doesn't want the respondent to know that they've complained? So we have a reluctant complainant, we might say, or someone who's requesting anonymity, but they want something to be done. So what do we do for notification of the parties? Does the investigation stop there since it can't move forward? This is probably something we could talk about for 20 or 30 minutes, but just to sort of, I guess, spot a couple of issues in this. Typically when we have a case where we learn of a reported act of sexual misconduct and our potential victim, if you will, expresses reservations, the institution needs to go through a multi-factor analysis as to whether you're able to defer to that potential victim's desires, and perhaps in a case that's a single incident of relatively minor harassment, maybe it's an unwelcome request to date someone, you might decide, what, we don't need to move forward, we can provide this complainant with some counseling and sort of document this and be fine. But if you have a serious report of a forcible rape, you might decide as an institution that you need to move forward irrespective of the complainant's wishes, much like the Doe versus Notre Dame case I discussed. So at the point where the institution decides, no, we're going to move forward despite your reluctance or your desire that we not, I think you would at that point be embarking on an investigation that could result in discipline, at which point you would be obliged to provide the detailed notice that the department is suggesting that you should. Okay. Here's a question. We had some discussion about the ability or the withdrawal, rather, of a sort of prohibition on cross-examination. And someone has asked whether does the cross-examination have to be face-to-face or can it be done through the investigator? So I guess there's a couple of things going on here. One is you would probably only have face-to-face cross-examination if you had a hearing-style policy or perhaps a hybrid where you actually had almost a trial-like setting. Many schools have moved away from that. Some still have it. And I think under the withdrawn guidance now, since that's been pulled away, you could allow face-to-face cross-examination, but you're not obliged to, certainly as a private entity. Now, if you're a public school, that is a school that is governmental, you have certain due process obligations, and there's a line of cases coming out of courts in the upper Midwest that say the right of cross-examination is fundamental to due process. You have to allow the parties to question each other. Those cases have said, however, that that cross-examination doesn't have to take the form of face-to-face cross-examination. It might be sufficient if the investigator is willing to sort of take questions from one party and then pose them to the other side. Or if you're in a hearing sort of setting, one side might be able to pose those questions to the hearing chair, who then asks them to the other party. And I know someone asked a question similar to that. So I think that's what we're getting at there with those points. We'll take one more question and then, apologize to the rest of you who we weren't able to get. We'll email this one for Elizabeth. Is there any guidance that says what type of process we must have at a university? Do we have to have a hearing process like Derek's been talking about, or can we have more of a single decision-making process?
Yeah, so there isn't guidance that says what process you have to use. We have the overarching, of course, guidance that your investigation and resolution process be prompt and equitable. And of course we have the guidance about what that looks like throughout. But no, there is no guidance that says you have to have one or the other.
Okay, and with that, I'm going to just share one tip that a participant has offered. It's a good point. It's one we get a lot of questions about. When you do share these preliminary reports with the parties, obviously, many of you have concern that, well, if we just email it to them, they're going to share it with their friends. It'll get out. It'll create, a big public airing of the case. So how do we accomplish that? One way is to only allow the parties to review it in person in a proctored setting, where you provide a copy in a room and you don't let them take it with you. But others of you, and the commentators noting this, have found ways through either Dropbox or perhaps your learning management software like Blackboard, where you can post the document electronically behind a password login which you provide to the parties, and then they can see it, but they can't download it or copy it, and they can't push it anywhere. They might be able still to take screenshots, I suppose, of what's on their monitor, but that's a pretty clunky way, and so you might be able to deter some distribution in that manner. With that, let me say just a few things in closing. Of course, we thank you for your participation today. If you haven't done it already, please click on the survey icon at the bottom of the screen. We have a short survey there, and we would appreciate your feedback. It helps us with our future programs. As a reminder, we have CLE credit for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. Indiana credit is pending. A recording of the webcast will be available tomorrow for watching and sharing, and once it is available, a link to the recording will be emailed to you along with the certificate of attendance. And that recording will be available for 2 weeks. Please be sure to join us for our next webinar scheduled for July 17th regarding Clery Act compliance. This concludes the webinar. Thank you for your time.